I think to understand what international labor standards are, we have to start by understanding a little bit about what the ILO is. The ILO, International Labor Organization, is a membership-based organization. But what's different for the ILO, unlike other UN agencies, is that we actually bring together also representatives of workers and representatives of employers. The ILO standard setting process actually deals with almost any question that you can think of in the world of work. Social policy, labor policy, those things are dealt with through discussions within the International Labor Conference, and these discussions can lead to what we call international labor standards. These can take the form of conventions, which once a government has decided to ratify a convention, it is then legally binding. It becomes part of international law that the government has agreed to bring its laws and practices in line with and to abide by the terms of that convention. And they provide policy guidance, more detailed guidance on how the government might address a particular theme. At its core, international labor standards are intended to set a floor, to create a level playing field internationally. So by creating that level playing field internationally, you can actually ensure that there are certain rights, certain basic principles, certain obligations that a country or a company couldn't undermine by what we call a race to the bottom, sort of competing more on your ability to innovate, your ability to produce more quality, to be more productive, rather than paying less or providing worse working conditions, etc.
So why ILS are needed for the country like Myanmar?
So why are these important for Myanmar? I mean, I think it's important in many, many countries. International labor standards can serve to support the efforts by a government to put in place a system of labor market governance, whether it be institutions, laws, regulations, or specific practices through a process of social dialogue. These international standards can help to support the government's thinking in terms of what policies does it want to put in place. So international labor standards can be a target for a country, and they can provide important guidance for a country when they're trying to look at ways of reforming and modernizing their labor market governance.
So could you explain about what are the ratifications of the international labor standards?
Sure. After an international labor standards is adopted, and as I said, every year workers, employers, and governments come together, usually in Geneva, to the International Labor Conference. And this is a conference that can bring together thousands and thousands of constituents from all around the world. And one of the main things that our conference does is it actually reviews and adopts international labor standards. So if a standard has been adopted in the conference, the government then has an obligation by virtue of its membership in the ILO to bring the contents of a convention or a recommendation or a protocol to the attention of the competent authority. That's usually the parliament or some decision-making body that could potentially take action, that could study the content of the standard and take action. So once that's done, the government can decide for conventions, not for recommendations again, but the government can decide to do what's called ratification. And they take a decision as a government, and this is voluntary because it recognizes the independence, the sovereignty of the government to decide what's best for its own people. Once you have a convention, it's not automatically applied to a government. A government needs to take a positive, affirmative action of ratifying. Once that happens, the government then agrees, it commits to bring its laws and practices in line with the terms of that convention. So any of the rights or obligations that are in the convention, the government says, we'll make sure that they're reflected in our laws, and we'll also make sure that the way that we implement our laws, the way that we enforce the laws, will ensure that the workers and employers can actually enjoy in real terms the rights that are in there. And they also submit to what's called a supervisory system. So the ILO supervisory system is a group of eminent experts, legal experts, labor issues experts who come together and review the practice of the government in relation to different international labor standards. So are the laws in line with what the standards say once a ratification has taken place? Is the practice actually in line with what the standards say. So, and they'll make observations, they'll make specific requests to the government sometimes when those things are not exactly in line. So the idea of the supervisory system is to help the government to bring its laws and its practice in line, in compliance with the rights and obligations that are in the international labor standards.
So why international labor standards is so important? And is there any international labor standards based on fundamental labor rights?
That's a really good question. Actually, in 1998, the members of the ILO came together and they adopted what was called the Declaration of Fundamental Principles and Rights at Work. And what this declaration is, it's a political tool, it's a political instrument that says, by virtue of being a member of the ILO, there are certain standards that are so important, certain issues that are so fundamental, core to the ILO, that just by being a member, you need to respect, promote, and realize the principles that are enshrined in those standards. And those cover four main areas. That's eradication of child labor, eradication of forced labor, doing away with all forms of discrimination, and then freedom of association and collective bargaining. And each of those has two core labor standards, core conventions that are associated with it. So even though a government has not necessarily ratified those conventions, it is committed by virtue of its membership in the ILO, coming under the ILO's constitution. It's committed itself to not only respect, but to actively promote and ensure the realization in real terms of the rights and obligations that are enshrined in those 8 conventions in those 4 fundamental areas. And that doesn't matter what part of the world that you're in, it doesn't matter the level of development, but all of the countries in their own way, with support from the ILO, technical assistance and technical support from the ILO, commit to working toward eradication of forced and child labor, doing away with discrimination, promoting equality, and then promoting freedom of association and collective bargaining. And one final point on that last one. It's really interesting. You've got 4 standards, 4 main principles there, right? 4 themes. 3 of them we're actually trying to do away with. So if we're ever 100% successful globally, we'll only have 3, and then 2, and then 1. But there is one that actually is a positive right. It's what we call an enabling right, and that's the right to freedom of association, to form and join trade unions and employers' organizations, and the effective recognition of the right to collective bargaining. And we call them enabling rights, because we recognize that by giving rise to those rights, by creating a situation where those rights can be fully enjoyed, well, we'll be actually more effective in addressing those other 3 principles and a wide variety of different labor issues in the world of work.
So could you explain a little bit more why it's important to have freedom of association and collective bargaining for the workers?
Sure, I would actually argue that it's good to have freedom of association and collective bargaining, not just for the workers. I would argue that it's actually really good for the employers to have freedom of association as well and collective bargaining. And I would say that the government also benefits and society at large benefits. So what I believe is that freedom of association and the effective recognition of the right to collective bargaining will actually help to unlock a lot of the potential in Myanmar's economy, in Myanmar's labor market. If you fight against the development of these kinds of free, independent, legitimate organizations of trade unions or employers, you end up undermining the democratic development of the country. You end up undermining the free exchange that can take place between those parties to ensure that economic development isn't happening just to happen. It's actually happening because we want to see the situation of the workers and the people of Myanmar actually come up. But the more workers that you have that are covered by collective bargaining, the less inequality you have in a country. And I think that there's a lot of recognition around the world that inequality is not something that we want to see. We'd like to see it shrink and not to grow, because inequality also can give rise to social unrest. It can give rise to a number of different things that can stand in the way of the democratic development of a country, but also the sort of balancing of social and economic progress in a country, and the poverty reduction goals that a government may set could be undermined.
So how international labor standard can help peaceful industrial relation with the workers?
There is a real contribution that respect for the development of free trade unions, employers' organizations that are independent of each other, independent of the government, they actually can work together very effectively to ensure that the growth that all of us actually want to see is a growth that's going to be shared. That the economic progress that we see is not going to be enjoyed by a very small number and having a growing number of people that are going without. So that the economic development actually raises the floor, and that it's done in a way that is the result of an exchange between the trade unions and the employers and their organizations. And the government actually benefits from that because they don't have to be so involved in dispute settlement. There's a recognition that they want to see peaceful, sound industrial relations. When you have mature industrial relations developing between a union and an employer at a factory level through effective grievance procedures. So you have a dispute, well, we've got a system in place that will help us to deal with it, which means we don't have to go on strike anytime we have a problem.
If workers and the trade union face violations of the international labor standards, so how can they take actions against those abuse?
Before they start thinking in terms of how they can take action at an international level with the ILO, I think it's very important for, first of all, the government working together with the employers and workers through a process of dialogue to ensure they have an effective system of dispute settlement and dispute resolution to deal with violations of rights here in Myanmar. It's really up to the parties to find the best system, the most effective, efficient, fair, transparent system that works here. Also, if you have a system of dispute settlement at the national level, well then you may not need to use a system at the international level. The ILO has two main systems. One is called the regular system, regular supervisory system, and then we have special procedures. Very briefly, the regular system of supervision, once a country has ratified, remember I said the government takes a decision, the parliament decides it's going to ratify, it signs the instrument and the ILO registers it, it then has a responsibility to report periodically on their laws and practice and how they are in line with international labor standards. When that happens, employers and trade unions have an opportunity to comment on the report of the government. And this goes to what's called the Committee of Experts on the Application of Conventions and Recommendations. A very long name. We also just call it the Committee of Experts. If a country has ratified a convention, the trade unions or the employers in the country can actually bring what's called a representation. And this is done under an article of the ILO Constitution, and this will be brought to the attention of the ILO governing body, which sets up a tripartite working group to look at what the complaints are. And they're saying, you know, that the government is not respecting this or that, you know, the working group will recommend to the governing body, and the governing body will adopt a series of recommendations for the government to help it to bring its practices or its laws in line with the convention. There's also the possibility of a complaints procedure. Now, this is something that can be brought by another member state, or by a member of the conference, or by the governing body ex officio. The governing body is the tripartite governing organ of the ILO. This is when there are persistent, severe, and very serious violations of commitments that have been made in ratifying a convention. And this can lead to commissions of inquiry, etc., etc. It's a very, very serious case. That happened in Myanmar years ago in relation to the Forced Labor Convention. The last procedure, and the reason that I mention it last, is because it's particularly important when you ask about trade union rights being violated. Now, if you have a dispute over the rights of a trade union, collective rights of a trade union, or even the individual rights of an individual worker who wants to form a union or who's acting on behalf of the union, there's a recognition that freedom of association and the effective recognition of the right to collective bargaining are so essential so core, that even if the government has not ratified the conventions, there has been a special system, a complaints-based system, called the Committee on Freedom of Association. Okay? Now, this is something that is established through the membership of the governing body, so it meets 3 times a year in private, and they will receive and treat complaints that are sent by oftentimes trade unions, but also employers, saying that their freedom of association rights have been violated. And there's a specific procedure to be followed there. And if they feel it necessary, they can actually put together a fact-finding commission to help work with the government, should the government allow it to enter, to address the issues. But then the Committee on Freedom of Association, the CFA, will review those things, review the facts, review the allegations, and make some recommendations. And they'll keep those under review until they feel confident that the government has brought its practices in line.
So when it comes to international standard, what if they don't follow, they fail to, ensure the rights of the workers after it comes to ratify the international labor standards? Then who can really take actions in this case?
Well, I mean, again, if a worker finds him or herself having their rights violated, their first place to go is the national system of dispute settlement and dispute resolution. So in the case of Myanmar, today it would be the conciliation body at the township level, the arbitration body if they're not happy with the result of the conciliation body at the state or division level, and then eventually the arbitration council at national level is the place that they would go to make sure that their rights are being respected. However, if those systems aren't working, well, then they can bring this to the attention of the ILO through the Committee on Freedom of Association, and this is something that many cases have come in that, and it's another way of making sure that those issues are being brought to the highest level, and the ILO can try and help, not just through the supervisory system, not just through calling the government before the governing body or before the conference to explain, but also through technical assistance.